What's going on, everybody? I wanted to do a video um, because the last video I was attempting messed up, and that kind of pissed me off. So I wasn't really too happy about that. But I'm going to talk about debt validation and why people are getting debt validation misunderstood. A debt validation is not for an argument. A debt validation is for a settlement, and we'll go over that today, so you'll understand how to structure your debt validations. um, and to stop, well, not to stop, there's many ways to deal with so-called debt. There's many ways to deal with it. But this is just one way, and it's probably will save you a lot of headache. And for some of the people who were on my 3-4 call, this is going to put a lot of things together for you. Okay, I got to go with my fragrance of the day, which is Oster, and we're going to go over debt validation. Okay, so a lot of times when people get debt validation, they think that it's someone, trying to force them to pay a debt. And really what it is the so-called lender who is looking for instructions. Okay. It's just like when you park, and, when you park a car, you get a valet, you get a ticket, right? So the ticket is your claim back to receive your vehicle. Well, the same thing with the debt validation. So when you send a debt validation letter, you will notice that they'll send you a pile of documents, and these documents are basically your documents. They're turning these documents over to you for you to do whatever you want with them. Now, I know this is contrary to what most people teach on the internet. And the reason why it's contrary is because the understanding may be different. It's nothing wrong with that. We're all trying to figure this out, and there's no manual for it. But I try to give you guys a little verbal or oral dictionary that you can use to kind of figure this out. So they're giving you your documents. So you have to look up what the word holder is. So let's look up the legal definition of the word holder, so you guys have a little clear understanding. So a holder in general is a general term for an individual who has lawfully received possession of property. For example, anyone holding a promissory note, check, bond, or other paper. So now you know that they are saying, hey, you have a vested interest in these documents. They're not sending it to you just to say you owe these documents. They're sending it to you to show that you have a vested interest. So you take a debt as a liability, but if you're watching this channel, you should know not to take a debt as a liability. A debt is an asset. Okay? When they send it to you, it's a payable to the bank and a receivable to you. Okay? Please understand that. And if you want to look up the term receivables, we may go on it through this call. So, holder is the term used to any person that has in their custody a promissory note, bill of exchange, or check. It should be entitled in his own name. Holder means a person entitled in his own name to possession of a negotiable instrument and to receive the amount due on it. What? Yes. This is why I keep telling you guys that your debts are not liabilities to you. They are assets. These people keep sending you money, and then you keep telling them you don't owe a debt. Of course you don't, because they're sending you an asset. Let's read that again. Let's bring it back on slow motion like a 90s R&B song. All I need is the raindrops to come down and sound the sound effects. Look, a holder is a term used to any person that has in their custody a promissory note, bill of exchange, or check it should be entitled in his own name. Holder means a person entitled in his own name to the possession of the negotiable instrument and to receive the amount due in it. So now, when I tell you that collection of debt is not what you think it is, do you now understand? When a collection agency is calling you, or when someone is calling you, like the bank is calling you, they are calling you to let you know that you have funds in your account that you need to disperse, or you are going to have to either pay it to their order, or you're going to have to claim the funds in the account. It's not that hard to understand, people. So I want y'all to stop looking at things as negative and to start looking at them as positive. Okay? So you have to understand, well, you don't have to, but you have to understand what a subsequent holder is. So when you get into a so-called agreement, which is not a contract, so we'll go into what a subsequent holder is, and then you'll understand even better. And there's multiple definitions, and I'm not going to use this one. Okay. I can use it, but I'm not. I'm just going to make it easier for everybody. So, oh my God, I'm just going to keep it on that page. Subsequent holder means any person that holds a Series A preferred stock other than the initial holder or an affiliate of an initial holder. Subsequent holder means each or any person which is a direct or indirect transferee of any of the rights, interests, or benefits of the lessor under this guarantee. So we'll go to another one. Here we go. So a condition subsequent, all right, that's not what I want. I know what subsequent means. So now you have to understand that you and the bank are holders. And because you don't have a contract, you have an agreement, the bank acts on your behalf because you're not acting. So the bank acts as a servicer. That's why they're in possession of the documents. And then what they do is they give you the documents because they're letting you know, hey, I'm your document custodian. I'm the document custodian on a record. Here's these documents for your record. What are you going to do with them? And what most people do, nothing. So we're going to go to this. I could go to the UCC, but we're going to understand what a holder in due course is, right? So this is what lets you know that they're not collecting debts. They're collecting interest. Big difference, okay? That's why you don't have to sign a credit card agreement. Why? Because it's not a debt. That's why it's called a credit agreement. All right, holder in due course. Subject to subsection C of this section and 28.3-106. It's going to be different in your state. This is all infused in your state law. Okay, holder in due course means a holder of an instrument if the instrument, when issued or negotiated to the holder, does not bear such apparent evidence of forgery or alteration, or is not otherwise so irregular or incomplete as to call into question its authenticity, and the holder took the instrument for value. I don't know why this does this. Okay, the holder took the instrument for value in good faith without notice the instrument is overdue and or has been dishonored, or that there is an uncured default with respect to payment of another instrument issued as part of the same series. Okay? Listen to what it says. The part of the same series. Don't you receive statements that are part of the original credit agreement? Yes, you do. That's what they're referencing. Okay. Without notice that the instrument contains an unauthorized signature or has been altered. Without a notice of any claim to the instrument. I hope you heard what I just said there. Without a notice of any claim to the instrument described. Somebody may want to look up what claims of the instrument is, and maybe you might want to, engage in that. I'm just saying. Without notice that any party has a defense or claim in recoupment described in section 28.3-305A. Notice of discharge of party other than the discharge of in an insolvency proceeding is not notice of defense under the subsection of this of this section, but discharge is effective against a person who became the holder in due course without notice of the discharge. Public filing or recording. See, you can record stuff like liens against your account. I would say that of a document does not itself constitute as notice of a defense, claim in recoupment, or claims to the instrument. So if somebody is binding you by an instrument, you have a right to claim that instrument. That's basically what they're saying. So except to the extent a transferor or predecessor in interest has rights as a holder in due course, a person does not acquire rights of a holder in due course of an instrument taken. So if it's taken by legal process or purchase and execution, bankruptcy, or creditor sale or similar proceeding. By purchase as bulk transaction, not in the ordinary course of business of the transfer, or as a successor in interest to the estate or or other organization. Now you're going to say, well, why are you talking about the UCC? You should be talking about consumer law. You should be talking about consumer law. And I've already told you guys about consumer law, so I don't have to go into consumer law anymore. Okay. There is elements of the FDCPA if you understand the Dodd-Frank. If you've never read the Dodd-Frank, if you've never read TILA, you really don't need all that stuff. But this is just basic instrument law because you're dealing with securities. You're not dealing in contracts. That's why the laws are different. Okay. So we're going to get into debt validation, and I'm going to show you that debt validation is not for you to argue a debt. It's for you to either to give out an order on the debt. So that's why if your credit is messed up, the problem is not you going in sending notices to the credit bureau arguing about the credit. The reason why your credit is messed up is because you're in dishonor. So since you're in dishonor, you have to bring your accounts back to honor. Okay. And I'm not going to go on that on this call, but I'm just going to go on debt validation so you understand and that you have these rights. So the Fair Debt Collection Practices Act is really to help you understand how to make your contracts not adhesion contracts. So I'm going to go over this, and I have certain information on private calls that I don't put on public calls, but this is mainly for a public purpose. And I want the people who take my private call, and you will listen to what I'm saying in here about claims to the instrument, things of that nature. And you'll understand. Okay, so debt validation or debt verification refers to a consumer's rights to challenge a debt and or receive written verification of the debt from a debt collector. The right to dispute the debt and to receive validation. Now, let's look up what the legal definition of validation is. So that helps you. So validation means confirmation by examination and provision of objective evidence that the particular requirements for a specific intended use can be consistently fulfilled. So, what is the actual meaning? To support or corroborate or on a sound or authoritative basis. So, experiments designed to validate the hypothesis, to recognize, establish, or illustrate the worthiness or legitimacy of validate his concerns. Now, let's see. Let's go to all right. And I'm going to go here. Let's see. Okay. So now, if you go into the etymology of validate or validation, they're looking for you to give validity to the debt. Now, why would they be looking to you to give validity to the debt? Well, your actions show if a debt is a debt or if you are the creditor of the account. So, just like it says, your actions, see? Past participle, validare, to make valid. Now, if I make a debt valid and I have a claim, right? If I have a claim to the instrument, then that might be something I might want to, I might want to talk about. Might want to share some time for discussion on. A person taking an instrument other than a person having legal rights of a holder in due course is subject to a claim of a property or possessory rights in the instrument or its proceeds. So if somebody is sending you a alleged debt in the mail, don't you have a right to claim the contract? Don't you have a right to claim the proceeds? Yes, it's saying right here, including a claim to rescind a negotiation and to recover the instrument or its proceeds. So you have a claim. So if they're sending you in the mail, why are you arguing about a damn debt validation when they're sending you money in the mail? You have people teaching you that you need to be arguing with these people. You need to be going into litigation. You need to, even in the Bible, it tells you, agree with thine adversary quickly. Agree with thine adversary quickly. It says it in the Bible. So if someone is sending you a bill, you have a right to claim the proceeds of it. Okay? I had a better video done for this, but this was just on my mind and on my head, so I had to get it out. Okay. The original video the audio didn't record. It was way more fire than this. But a person having rights of a holder in due course takes free of the claim to the instrument. So you wonder why you get adhesion contracts from banks. You wonder why the bank doesn't listen to you. You wonder why you can't get the bank on the phone or you can't get nobody of power on the phone to talk to them, right? Whenever somebody sends you a debt in the mail, you have a right to claim it. So I know people on the internet like, what? Yes, it is money. They are sending you an asset. A debt is money, fam. It's not what you think it is. It's how you approach it, how you take the debt. If you take the debt and you think you owe it, then that's what it is. That's why they send it. It's like a jump ball in basketball. So if you think you owe the debt, you owe it. If you don't, then if you think, hey, that's my fucking money. Oops, I'm sorry to curse, but that's my money. It's my money and I want it now. You have a claim to it. Why? You might ask yourself, why? Why is debt money? Okay. If someone is sending you a debt, it can be turned into a negotiable instrument. That means that anything can be. So look, this section expands to the reference to claims to the instrument mentioned in former sections 3-305 and 3-306. Claims covered by this section included not only claims to ownership, but also any other claim of property or possessory right. It includes the claim to a lien or the claim of a person in rightful possession of an instrument. So if you do a debt validation, guess what? They gave you the instrument. So you're in rightful possession of it. Okay? Who was wrongfully deprived of possession. So if you sign off at a dealership and you get a car loan, right? The dealer takes your note, which is transferring your interest, sends it over to the bank without recourse, which takes your claim and transfers it to a non-recourse loan. They transferred your interest, so you instantly have a claim, but you never file it. So, also, a claim is based on Section 3-202 for rescission of negotiation of the instrument by the claimant. Sounds like something that could clean up your credit, right? Sounds like it, right? Sounds like something that can clean up credit. Claims to an instrument under Section 3-306 are different from claims in recoupment referred in Section 3-305. A3. So, when you're doing debt validations, they are giving you what is called a presentment. So, what is a presentment? A presentment means a demand made by or on behalf of a person entitled to enforce an instrument. Why are you both entitled to enforce the instrument? Because you have an agreement on file. Okay? So, to pay the instrument made to the drawee or party obligated to pay the instrument, or in the case of a note or accepted draft payable, see, accepted draft, an accepted draft will be an agreement. An agreement is not a contract. They're two different things. So, an agreement can be a contract, but it's not. At a bank, to the bank, to accept the draft made to the drawee. So the moment that the bank accepted your draft, they were already paid. Okay, do you get that? So that's why when you do a debt validation, they send you all your documents. They're not sending you all your documents because they're telling you you owe us. They're sending your documents because they're looking for you to give them an order. Presentment may be made at the place of payment of the instrument and must be made at the place of the payment if the instrument is payable at the bank in the United States. May be made by any commercial reasonable means, including an oral, written, or electronic communication. What? So you can call them on the phone and give them an order to pay the instrument to your order? Yes, you can. Now, if you read your agreement, it'll say that you can't. So, but you can do it either written or electronic. Okay? Is effective when demand for payment or acceptance is received by a person to whom presentment is made, and is effective if made to any one of two or more makers, acceptors, or drawers, or other payers. Now, when you get a note or when you get an agreement or you get a draft, right? You notice that it's two names. It's their name and your name. So what it is it's very ambiguous. So the instrument is ambiguous, so you have to study instrument ambiguity. So I'm not trying to go all day on this call because there's enough information that I'm giving you. Okay, so now we'll get back to the debt validation. Okay, so let's see. So the right to dispute a debt and to receive validation are part of the consumer's rights under the United States Federal Debt Collection Practices Act. And most of y'all don't know that, like, this is in state level too. So they just use the FDCPA because people do interstate business. That's what the FDCPA is for. It's to protect people on all grounds. So you're protected if you do interstate commerce, and you're protected if you do state commerce. The FDCPA and are set out in subsection 809 of that act, which has been codified in Title 15, Section 1692-1692P of the United States Code. This debt validation procedure was expected to reduce the incident of debt collectors during dunning the wrong person or attempting to collect previously paid debts. Now, if you remember my video, what did I say? That the FDCPA is there to protect the debt buyers, people who buy debt in the secondary market. Some of us do it unknowingly too. Some of us are buying debt in the secondary market. So it's to protect you just in case there's a claim to the instrument or a claim to the proceeds. Under the Fair Debt Collection Practices Act, any person or entity, including lawyers, who regularly attempts to collect consumer debts is considered a debt collector. See, including lawyers. So any person, including lawyers, who regularly attempts to collect consumer debts is considered a debt collector and is therefore required to respond to proper debt validation requests. That means if you're going into court and a lawyer is sending you a notice, you can do what? A debt validation. And you could stop a court case just by doing this. So in some instances. So, but you got to know what you're doing, okay? In contrast, the original creditor and its employees are generally not subject to the FDCPA, though they may be regulated by other state and federal laws, which is the consumer acts of your state. I know people don't know that because everybody on the internet is pitching you the FDCPA. But me, I'm always state law, because if they sue you, they're bringing you in state court. They're not bringing you in federal court unless the amount is over $75,000 in most instances, or if there's certain federal elements, including the Fair Credit Reporting Act, which was modified by the Fair and Accurate Credit Transaction Act in 2003. The original act excluded lawyers from the definition of a debt collector by explicitly exempting them from any coverage. So if you hear attorneys tell you this bullshit that attorneys are not debt collectors, they are. See, any at-law attorney collecting debt as an attorney on behalf of and in the name of the client. So let's go back to that again because I was yapping. So the original act excluded lawyers. See, the original act excluded lawyers, but they came back with a revision act which added the lawyers in as debt collectors. So the original act excluded lawyers from the definition of debt collectors by explicitly exempting from any coverage any attorney at law collecting a debt as an attorney on behalf of and in the name of the client. The definition of debt collector was amended in 1986 to omit the prior exemption for attorneys. Despite the amendment, some attorneys maintain that litigation, any attempt to collect the debt, did not bring them within the definition of debt collector in 15 USC subsection 1692A6. That is 150% bullshit. Because if you're being sued, you are being sued by that attorney. Now, one of these days, I'll show you how these attorneys get these files and how they are able to do that, but I'm not doing that today. This issue was not resolved until 1995 when the Supreme Court determined that the FDCPA applies to any attorney who regularly engages in debt collection activity, even if it includes litigation. Boom. So that already debunks 95% of these attorneys on the internet telling you that when an attorney is sending you a notice in the mail that it's not the attorney. It is 100% the attorney firm collecting the debt. 100%. Now, they may have an agreement with their client to return the property, but if it's a foreclosure, then the property becomes an REO, which is real estate owned, so the bank can't own it. Now, they can manage it, but they can't own it. So now that you have knowledge that a debt validation is a presentment, okay? So remember, it's a demand made by or on behalf of a person entitled to enforce an instrument, to pay the instrument, to instrument made to the drawee or party obligated to pay the instrument, or in the case of the note or accepted draft payable at a bank to the bank. See what I'm saying? So you can actually take your debt validation and either change your agreement or endorse it for payment. So I hope we've had a great, knowledgeable, and enlightening few minutes. And I hope that this information works for the people who understand this. But yeah, you have to understand what a debt validation. A debt validation is not to argue any debt. It's to accept the debts that you've created. I'm out.